First off, Tripp Watson, Watson Firm. Today we're going to be talking a little bit about the Alabama LLC Act. I'm going to kind of break it up into two sections. We're going to talk a little bit about the Act, the changes that are coming down the pipe, but then I want to open it up some other questions because, as I mentioned previously, there's some gray lines that get kind of blurred around some of these edges, and so it's important to know where these go. There's also a disclaimer. This law goes into effect beginning of next year. We don't know how this is going to look. It's going to rely a lot on Delaware law. We stole a bunch of the clauses from Delaware law, and so surely if this goes to litigation, we're going to see a lot of folks referring to Delaware as far as corporate matters are concerned. But big picture today, topics that we're going to cover. Current LLC requirements, a brief history on how we got the LLC law, and then current requirements in Alabama based upon that, changes that are on the way, and the effects that these will have on choice of entity decisions, whether or not you go with a limited liability partnership, traditional corporation, and whatnot. So we'll start off with a brief history of LLC law. LLCs originally started, the concept is a German concept. I am not even going to attempt to pronounce that, but that is the legal basis that many of the states use to create the limited liability company in the United States. That is, the GmbH is the most popular form of business entity in Germany. They do have a traditional corporation that has shareholders, that kind of, but it's significantly less favored to the GmbH. And basically what ended up happening was it was enacted in 1892 when the Industrial Revolution was just starting up, and that was kind of the default business entity over there. Fast forward nearly 100 years, and Wyoming decides that they're going to enact this law, which was basically, it was an oil company that petitioned Wyoming to implement a German-style LLC law. And so Wyoming was the very first ones to do it. So they enacted it for this one sole purpose, so that this one oil company could come in and drill. It didn't take long for it to catch on in other states. In 1982, Florida passed a law to do the same thing, and finally the IRS had to take it up and change their decision in 1988, saying that they would treat LLCs as partnerships as opposed to taxing it as a separate entity. And that's when the dominoes started to fall. As soon as you realized that you could set up a pass-through entity that had the same legal protections as a traditional corporation, most of the states started implementing the same types of laws. In 1993, Alabama adopts our first LLC Act. That's the first time that we recognized an LLC. In 2011, we amended it. It was the result of a 2008 law that was passed in 2009. And most recently, this year, we enacted a new update to that same law that goes into effect the beginning of next year. One of the misconceptions of LLCs is because they're a relatively new legal concept that they're not as legitimate as, say, an LLP, a professional corporation, or a traditional corporation, period. That's not true. Here are some famous LLCs. AOL, when they were owned by Time Warner, they were structured as an LLC from 2001 to 2008. BMW North America, their American subsidiary, is a LLC completely. It's based in, I think, Delaware. Chrysler as well, after they went through bankruptcy and restructured under Fiat, they are now an LLC, again, I believe based out of Delaware. These are very, very large companies. The reason that you see large companies opting to take an LLC business entity is because of the flexibility that you were allowed in the corporate governance concept. And I'll get to a little bit of the specifics in just a second. But really, the only hindrance in doing an LLC for most companies is that you can't go public. You cannot have a publicly traded LLC. You can have a holding company that's a traditional corporation that has an LLC subsidiary, and that holding company is public, but the LLC itself cannot be public. Which means that if you're trying to go public, you're going to have to do a corporate restructure at some point. if you start out as an LLC. Amazon did this. Amazon had a corporate restructuring. I believe they started out as an LLC, and they might still have subsidiaries that operate as LLCs, but their overall corporation had to be turned into a traditional corporation to be traded on any major exchange. So this is not, we're not talking about a business entity that just exists for the purposes of some guy to open up a plumbing shop and drive a truck around. We have major manufacturers across the country that are operating as LLCs, and the reason is because the limitation of liability and the flexibility that we have in order to operate the company. And we'll get into it, but it also significantly cuts down on some of the legal expenses in the long term, but typically pushes a lot of those legal expenses up. So I'll talk a little bit about that. As I mentioned, the law was updated in 2011, when effective 2011, and it didn't take us long for us to completely redo it. So the current law has only been in effect for a couple of years. So we're going to talk a little bit about the requirements that go into registering an LLC and maintaining an LLC in Alabama now. Right now, formation is simple. You just register with the state and then file it with the county. It's a very simple process. There's forms on the Alabama Secretary of State's website that help you do it. The benefit is that they can start off with a single member. You don't have to have a slew of shareholders. You don't have to have two partners like you do in a limited liability partnership. You only have to have one guy. He takes a piece of paperwork, takes some paperwork down to the county courthouse, registers everything, and he's good to go as of the effective date of filing. All you need is the name, the initial members, and a business purpose really on the formation paperwork, as well as the appointment of a registered agent. 2 months after you file it, you file a business privilege tax with the Department of Revenue. Very simple process to get these things set up. It doesn't require, say, for instance, as like a traditional corporation has, it doesn't require the formation of bylaws. It doesn't require shareholders having evidence of their shares. It doesn't require reporting to the IRS the individual shares of who all owns what, how much, what percentage. It's a very simple system to set up. As far as maintaining the LLC, again, very, very simple. Traditional corporation requires annual board meetings, shareholder votes. It's a very complicated process. People didn't want to do this, and that was part of the reason that LLCs became popular, so none of those are continued requirements. In the state of Alabama, you have to maintain a registered agent in the jurisdiction. If you move your address, you are under a duty to notify the state of Alabama that you've moved, because somebody's got to serve process with you. That's one of the biggest issues that we have with companies that move, is they don't update their records with the state, and that can be used as grounds to pierce the veil, which we'll talk a little bit later, and that's bad news if you're a shareholder. So it's very, very simple to maintain. Finally, you have to, or secondly, on the maintenance, you do have to have a business privilege tax that's paid annually. Alabama is one of the about 7 states that requires an annual filing. This is a nominal filing. It's about $100 per year per LLC, and it's not based upon revenue. Some states have a revenue requirement. I believe California does, that if you make a certain amount of revenue, you have to pay to the state a certain income tax rate on that, but I think it caps out around $500. Alabama, $100 flat. Doesn't matter if your business did $1,000 worth of revenue last year or $2 million. Doesn't matter. Finally, these are the items that you don't have to register with the state. These are, you have to keep your membership listing, all official documents, and financial records in a central location, preferably your principal office address. And all of those have to be kept and maintained so that other members can access them at any time. Now, if there's costs involved with printing out some of the records, then the member has to pay, can be charged by the company for reasonable expenses. But in this situation, it should be very reasonable for a member of an LLC, a full member, to walk into the principal office and say, I would like to see last month's P&Ls, and they should be readily provided to them in a reasonable time period. As far as liability, this is another misconception of LLCs. There's the misconception that because they are not traditional corporations, they do not have the same level of protection against third parties. Not true. Alabama recognizes full limitation of liability with the exception of initial and guaranteed capital payments. And I'll clarify on that. But the big point I want to make first is that LLCs don't provide a lower level of protection. That's a common misconception. Typically, a lot of attorneys that have been practicing for a while that LLCs came about, and they're still a little bit skeptical about the form. You're going to see a lot of folks that will say, a lot of attorneys that will say that. Practically speaking, the code provides for the same thing. Alabama's code section is what we call a hub and spoke. So there's actually a central law that governs all business entities. And then there are separate laws that govern each specific entity. So the same central laws apply to all of them, and that includes a limitation of liability. It protects an LLC, it protects a corporation, and then every single individual act has its own tweaks on what's required of it. So this limitation of liability is the same no matter if you're a corporation or if you're an LLC in Alabama. So that's a common misconception. Where it does not protect you is initial and guaranteed future capital payments. In order to start a business, it needs to be properly capitalized. That's one of the requirements that if you are going to pierce the veil, a lack of proper capitalization can be shown as reason why the company isn't legitimate. Now, there's no set hard and fast rule. If you start an Etsy business out of your basement, your capitalization may be $10. However, if you're starting a major manufacturing where you're going to be doing defense work, you're going to have entire assembly lines, starting out with $1,000 and saying, oh yeah, we're going to loan $3.8 million so that we can purchase a manufacturing facility, $100 is probably not going to be sufficient capitalization. However, once that's in, it's owned by the company. It's the consideration paid for being a member in the company. Now, some agreements will also provide for future guaranteed capital calls. That's generally what they're called, is capital calls. So say, for instance, we only need $100,000 right now to get the business set up, but we will need $200,000 in 3 years when we inevitably run out of money. This is a capital call at the option of the company. If it is mandatory, this could be potentially part of the liability of an LLC. So say, for instance, you have a business that's starting up. They know that they're going to need to buy so much equipment, but they know that it's going to be a lag time before they really start making money. They don't want to just completely burden their investors, so they want to have 2 rounds of investment. They say one is $100,000, second is going to be in 3 years for $200,000. Say, for instance, after the $100,000 gets funded, lawsuit happens in year 2. The lawsuit says, well, you've breached a contract, we're on the hook for $200,000. Technically, they couldn't recover against the LLC itself because there might not be any assets left. And certainly, if there's $100,000 to start, there might not be enough assets to cover a $200,000 judgment. There is an argument to be made that that creditor, when the capital call comes due in year 3, is entitled to some of that money. Current situation, that's how it's structured. So, your limitation of liability is only the amount of money that you've either already put in or promised to put in the future. You can also be liable if you are a member for bad acts to the company. So, in the situation I mentioned before, say for instance you are the member of a LLC, somebody comes in and offers you a job working at a competitor. Say for instance you're a high position individual in that competing company. You might have breached a duty to that LLC because you have a fiduciary duty to the company. And if that competition creates damages for the company, you're stealing customers, you're otherwise bad-mouthing the company, then that could create a liability for you as a member to the company.
So these liabilities, the first one indicates a third party, typically outsider,
yes,
who could get that promise to pay capital call.
Yes.
The second one is the member may be liable for like an employment breach or
You're right. This is third-party liability. This is member-to-member liability. So if we're two members in an LLC and you start working against me, I can sue you on behalf of the LLC, saying that you are breaching a fiduciary duty that you owe as an owner in this company.
So non-competitive kind of law or non-compete agreements or something could
Yes
apply?
and no. Non-compete laws are subject to contract law, and they are also subject to employment law. Alabama actually has a specific non-compete law in 8-1-1, I believe, that specifically says that non-competes are not enforceable, but they practically do get enforced. This is a different issue.
Okay.
This is, you are the owner of a company,
Yeah.
in the same way that if you appointed somebody to manage your 401k, it creates a fiduciary duty to the company to not act against the company. It's different than contract, it's different than employment law, because even in Alabama, at-will employees have a very minimal duty to protect the company, at-will employment state. So in this type of a situation, you can have somebody that...
So that's a fairly high level of responsibility.
Yes. So if you are, it's the same thing as if you were going to be on the board of directors of a major corporation and you're feeding them bad information. Well, the company's probably going to sue you. It's a very high level. It's a fiduciary duty that's created, at least under the current law. So I'll clarify that. Under the current law, this is the rule. Which is great, because if you do get into business with somebody that decides to stab you in the back, you do have some level of protection. And a lot of these cases come down to argument over whether or not it was a reasonable bad act. But that's a different kind of conversation. Finally, as far as dissolution is concerned, dissolving the current LLCs is very, very easy. You just sign a piece of paperwork with all the members, according to the operating agreement, if you have one, saying we want to dissolve. You put all your creditors on notice, and it's gone. So, very, very simple so far as Alabama is set up. Now, if you can imagine it, it's about to get simpler, and that's bad. So there are several changes on the way coming down the pipe. The new code, the old code was Code of Alabama, Section 10A, subsection 5. The new code is Code of Alabama, Section 10A, subsection 5A. It will replace 5. For whatever reason, whenever we add A's onto these, we never get rid of the original codes. They just kind of hang out there.
The constitutional precedent, isn't it? The way we do constitutions around here.
Yeah,
So it's
pretty much.
10A, 5A? Or?
Yes, it's 10A, 5A. In the same way that the criminal code is 13A.
Right.
It replaced the previous 13 code. 10A was the change that was made in 2008, and it added on to Section 10. Now we have 10A, which went into effect in 2011, and now we have 10A, 5A, which is going in now. So try not to complicate that too much. These are very easy to find, by the way. The Alabama Code is very well updated online. Just type in a quick Google search. Frankly, I go there a lot. It's maintained by the Congress in the state of Alabama. Just type in Google. It's typically the first hit. You can find the code sections very easily. As bad as Alabama's Constitution is, our code section is actually pretty well maintained. It's easy to navigate. Highly recommend, if you're looking for a quick answer on something, you could check it out very easily. Do not, however, try to look for a constitutional amendment, because it will take you far too long. Anyway, long story short on this one, this new code 5A is effective on January 1st, 2015. The legislative intent, which is very clearly stated in the bill itself, is they want to preserve the right of contract. Now, LLC law is kind of a blend of corporate law and partnership law, but the primary law is partnership. They want two individuals or more to be able to sit down and say, this is how we want to work. So that's partnership law. But they still wanted to provide the same level of protections that to third parties that are provided in corporate law. So they wanted to do that, but there have been default rules that if you didn't address it in an operating agreement, you could still be liable for something. So what they wanted to say was, we want people to sit down and have a conversation about what our expectations are as far as our working arrangement. So they want to preserve the right to contract. They want partners to be able to work within their own ways. And they also wanted to legitimize existing business practices. This is a little controversial because you had a bunch of single-member LLCs that were doing things that they shouldn't have been doing. And basically the law is going to say, you know what, we're not really concerned that you've been screwing us up for the last 3 years. We're just going to make it legal and recognize it and move on. That's a problem. Several folks have already pointed out that this is going to create problems for minority shareholders in an LLC. But it's kind of a recognition that people were doing this anyway.
Like, what were they doing that was a little shady?
So for instance, you would have two guys say, hey, we should totally start up a company. One of the guys files an LLC. They never think about it again. They don't do an operating agreement. They never actually sell anything. And then you had one guy who's like, nothing's happened on this. I'm going to start my own business, whatnot, and do something else. Technically, he's breached that fiduciary duty. So what they were saying is basically, if you're not going to maintain the LLC, if you're not going to do it, we're just going to make it completely legal and make y'all fight it out in court. We're not going to have a very clear code provision on this. We're just going to let y'all deal with this under partnership law. So the other big thing is the existing law is repealed. It's gone. 2017. If you have an existing LLC and you do not opt to be covered under the provisions of the new 5A law, it doesn't matter. In 2017, you're now under it. So if you do not update your LLC documents, you are still bound by the law, effective 2017. This is also going to create some problems because you're going to have some folks that have had the same operating agreement since 1993 and they haven't updated it. And there's going to be some big changes that come through that are going to change the way that that contract is interpreted and the way that the operating agreement is recognized. So, two big dates. If you file anything after January 1st of next year, it's covered under the new law. If you still have something and you don't elect to be treated under the new law, you can still file an amendment saying, hey, we're under the new law. You can do that anytime before 2017. But effective 2017, all the old LLCs are covered under the new law. 10A-5 will cease to exist. If you look at it on the website now, it even says, will be repealed effective January 1st, 2017. So that code section will literally not even show up if you search it online. So, major changes that are coming down. Some of these are exciting, some of these are a little bit dicey. Big one, the one that I'm excited about, series LLCs. These have popped up in a couple of states so far. Some big ones being California, Texas, Delaware. Series liability means that you can take an LLC and it can have subsidiaries inside the LLC without filing a new LLC. This is very good if you're trying to maintain all the legal documents in a central place without having to file. For instance, when my father was running his business at their height of corporate madness, they had 42 separate LLCs. Potentially, you could roll 42 LLCs into one and have 42 series. Now, the benefit of the series is every single series operates as its own individual company. So the LLC becomes a holding company, and the series becomes the operational subsidiary. So it can have its own assets, it can have its own business members, it can have its own liabilities that don't affect any of the other series. So say we set up a holding company, and we say, I'm going to be the member of the holding company LLC, but then we're going to break it down, and this first series is going to be a partnership between me and you. And this is going to own one car. But then we're going to have a separate series within that LLC where a partnership is between me and you. And this is going to own a house. If this business goes bankrupt and the mortgage folks sue for the LLC on the house, they can't come after the car. It is a completely different bucket. If you properly do it, You can have all this covered under the exact same LLC, even though there's a common member involved, but there's segmentation as far as the LLC is concerned.
Okay, let me ask this.
Go ahead.
Okay, so we've got now, say, my husband opens his LLC with his partner, whatever.
Mm-hmm.
And so, and then, but we want to open another series or whatever
Mm-hmm.
that's going to contract out to somebody.
Mm-hmm.
That can be, I mean, that's, so the liability is with this, not with the main.
Correct. You can potentially have a series within an LLC that owns lots of assets, and that series owns no assets.
Okay.
And it's the outward-facing one, so that if anybody sues it, you can potentially have no assets in that series class. Now, still going to see how this works out when it goes to litigation, but that's at least what the law says.
Okay.
So long as you still have it adequately capitalized on the front end, and you maintain the basic requirements for maintaining it, then you're good to go. So
Any notification requirements?
you have to register it with the state and say that we are going to opt for series. And I do believe that you have to state which series exists when you file it with the state. So when we're starting out, we have Series A, Series B, Series C.
Okay, so like if we open an LLC today and then 2 days from now we say, oh, you know, we want a series.
Yes.
So we have to file the paperwork for that LLC?
We have to
And
disclaim that we also have these 3 series.
Okay.
This is part of the requirement that's already out there. For instance, if you file an LLC now, the default is not that the company can indemnify you. This is a common misconception. That if I work on behalf of the business, say I make a representation on behalf of a contract, and maybe it's a completely reasonable representation, but I get sued personally for fraud. The default is the LLC can't step in for you because fraud is an individual action.
Right.
However, you can opt for the LLC to indemnify that person if they made a reasonable representation, for instance, through the normal course of business. However, that has to be disclaimed. You have to say in your articles of formation, we are taking on, we as the company, the LLC, is taking on the responsibility of indemnifying our members for these acts. And if you don't do that, then you don't get that protection. There's a couple other things that you have to disclose too. For instance, if you have multiple classes of individuals, so say for instance you have somebody that's a 10% owner, but they're a preferred share, you know, there's different ways that that's treated too, but they have to be disclaimed. That's not the case anymore. The registration requirements are going out the window. The state of Alabama doesn't want to keep any of that. They want you to keep it on your operating agreement. They want to have the basic minimum disclosures. And I believe that the Series LLC notification is the only thing that's required now in addition. The other big things, everybody I'm talking to is petrified of this next one. An operating agreement can be oral or implied. Anybody that knows basic contract law, a written agreement takes precedence over anything. Well, what happens if you never put in an operating agreement? What if you never even talk about how you're going to operate? And as a practical purpose, every single time the distributions came around, I paid to you 50%, I paid to you 50%, and I didn't take any distribution. The implied operating agreement might therefore be that I'm a manager. I'm entitled to none of the assets. You're entitled to 50, you're entitled to 50. That's the problem that we have with the recognition of implied operating
You have to let a
agreements.
judge decide, right?
Yep. You got to take testimony, and it's going to be an expensive litigation process. So the biggest thing is this is part of we're recognizing what's already going on is people literally filing an LLC and thinking that's all they need to do. So we're recognizing that. That's legal. We're allowing it. We are now saying that you are allowed to have an implied operating agreement, and we're giving you enough rope to hang yourself with.
Now, but if you have a written agreement,
It should take precedence.
it should, well, I like that word should.
There's a case that came out of Delaware that seems to suggest that in the absence of a specific term in the operating agreement covering this one particular issue, that an implied agreement about how that was working.
Okay.
Yeah, so I give you the lawyer answer. It depends. But generally, the written agreement should take precedence. Secondly, the operating agreement now takes precedence, period, then the law. The default rule in any kind of contract law is that if there is a policy of the state that overrides a particular term in the contract, that contract term goes out the window and the law states what the law states. Not so anymore. Alabama's going to put in some default rules, but we're going to allow you to contract around them. So if you have a written agreement that says, hey, you have no fiduciary duty as a member. You're a 100% member. We're putting you 100% in charge of this whole thing. We're all putting money into it. But you know what? You can sign up to work for another competing company tomorrow, and we don't care. State of Alabama doesn't care. If you're wanting to contract out of that, that's your own mistake.
So there's be no longer being able to sue because you're not fulfilling your duties? Or?
If it's in the operating agreement.
Okay.
So you can absolutely take what's in the Act and throw it out with the bathwater. Fiduciary duties to LLCs can now be eliminated, like I just mentioned, in that written agreement. You can say, hey, guess what? We're not going to do this anymore. I don't want to have a fiduciary duty. I'm not going to do it. It's too much of a liability. I want out. And the other members can put on a piece of paper, you do not owe a fiduciary duty of any kind to this company. That's dangerous. Because you're going to have somebody that writes a 2-page paragraph and throws in there, I have no fiduciary duty. And somebody is going to use this and say, hey, listen, it's in the contract, and they're going to get away with it.
Now, why would you not want to have at least someone with fiduciary duties?
Of course you want that. You want, it has to be in the contract. It has to be clearly provided for and removed. If it's not, then it doesn't matter. So why would you want somebody that's handling a bunch of money for a bunch of investors not to have a fiduciary duty? That's stupid. I can't think of a scenario in which you might want to tailor it. Like, for instance, we're not going to hold a fiduciary duty of loyalty. So you are allowed to work for a competing company so long as we're aware of it. A wholesale removal of fiduciary duty, that probably will never happen. But on a case-by-case basis, they're going to say, hey, you know what? We're not going to hold you to a fiduciary duty of negligence. Maybe something that you intentionally do to hurt the company, we're going to say that that's illegal. But something that you do knowing that it's a risk and you do it anyway and it just happens to have a bad result, we're not going to hold you liable for something like that, for instance. I see this being tailored, not completely removed. It doesn't necessarily say that there's not going to be somebody that gets a little crafty and throws in a line on venue that they're going to do something like this. There's going to be somebody that takes advantage of this. You can also now sue for bad faith. This is a different issue. Bad faith in Alabama is only recognized for insurance. It's when the insurance company doesn't pay, and the only reason is because they don't want to pay. This is really the only context in which bad faith is recognized in Alabama. However, we've adopted this law from Delaware. Bad faith is recognized as a cause of action. So if you do something, and who knows if it's not covered under some specific fiduciary duty or some specific responsibility in the operating agreement, under the new law, potentially you can get somebody on a catch-all and say that it's just bad faith, that they didn't do this, that they weren't supposed to do it necessarily, but they should have done it, and because they didn't do it, then that was a problem. So bad faith is new cause of action. So we're still going to see how this is going to work, but I see a lot of reference to the Delaware law, which this is based on, if it goes to litigation. Because there currently is no law on this. If you did bad faith search in corporate law and litigation, you would not find a case. This is another interesting one. Liability for breach of contract can be eliminated. You can say in the operating agreement that this operating agreement is a go-by. It's not really an agreement. It's not even a contract. This is just a set of suggestions that we're going to put on people. And if you breach this agreement, no harm, no foul. Again, I see some problems with this because you can put in that same guy that's going to put in there, I have no fiduciary duty to my other members. He's also going to put in there, if I don't follow this, there's no damages. You can also probably cap the liability. You probably practically will see people tailor this to cap a liability. So, for instance, if you do something bad to the company, we're going to cap your liability at $1,000, and we're not going to hold you responsible for anything more than that. Or we're going to kick you out as a member, and that's about it. So there might be some equitable remedies. I see somebody taking advantage of this as well, saying, oh yeah, this is our implied oral operating agreement, but we also agreed that it was a go-by, so even though you told me as a managing member to do this, I didn't have to do that. And because it resulted in $100,000 damages to us, I'm not really on the hook for that. There's going to be some problems with this. There are also now written penalties for non-performing members. It didn't used to be allowed that, say, for instance, you had that person that was in the operating agreement. You have to show up for our members meeting. Say, for instance, you had an operating agreement that said, we are having an annual members meeting, and you are required to be there. It used to be a little bit of a gray area if somebody consistently failed to go to such a requirement or meet that meeting, that you could potentially remove some of their membership interest. So every single time you fail to show up, we're docking your interest 10%.